Please call the next case.
Melissa Salmon versus Fellowship Bible Church of Williamson County.
If you would pause for just a moment so that they can clear. All right, thank you.
Good morning, Your Honors. May it please the Court. Daniel Horwitz of the Nashville Bar on behalf of Appellant Lisa Salmon. Would like to reserve 3 minutes for rebuttal, please.
3 minutes, yes, sir.
This is an important case about whether Tennessee public policy forbids parties from contracting to conceal child sexual abuse. And the trial court's errors below were legion, but I am here today arguing that you should simplify the merits of this appeal to just the first issue presented. Whether the trial court erred by granting the defendant's motion to dismiss Mrs. Salmon's declaratory judgment claims. Because the trial court did err, you should then reverse the trial court's dismissal order, vacate the balance of its ruling, and remand for further proceedings. Turning to the issue of whether the trial court erred by granting the defendant's motion to dismiss, this court is obviously familiar with its repeated guidance that motions to dismiss are rarely appropriate in declaratory judgment actions. Instead, the prevailing rule is that when a party seeking a declaratory judgment alleges facts demonstrating the existence of an actual controversy concerning a matter covered by the declaratory judgment statute, the court should not grant a motion to dismiss, but instead proceed to render a declaratory judgment as the facts and law require.
In other words, just declare the rights.
That's right.
Winner or loser,
That's right.
Declare the rights.
And based on that standard, the only merits question that this court needs to answer is whether my client's complaint alleged the existence of an actual controversy concerning a matter covered by the declaratory judgment statute, and clearly it did. Mrs. Salmon's complaint alleged that the challenged provisions in the parties' contracts are void as contrary to Tennessee public policy, something that the defendant disputes. That is an actual controversy, and to make that determination, this court does not need to look any further than Judge Bennett's opinion in Carcinovich versus Kempe. Judge McBrayer, I believe that you were on that panel as well. The Westlaw citation is 2018 WL 1091735. There, this court held that the plaintiff's complaint for declaratory judgment pleaded sufficient facts to demonstrate an actual controversy existed for the court to address whether the challenged provision in the parties' contract was void against public policy. This case is on all fours with Carcinovich. There, as here, the parties had an actual controversy over whether a provision of their contract was void as violative of Tennessee public policy. What happened next is the same here too. In Carcinovich, this court explained that the trial court granted Ms. Kempe's motion to dismiss and then ruled on the merits of the complaint. Judge Bennett, you wrote that this illustrates that there was a controversy for the trial court to decide. Therefore, the trial court erred in granting Ms. Kempe's motion to dismiss because there was an actual controversy which it subsequently ruled on. The exact same thing happened here. Because the parties obviously had an actual controversy over how Tennessee Code Annotated Section 2934-103 affects their contract, the trial court ruled on the merits of that controversy. That alone illustrates that there was a controversy for the trial court to decide, and therefore the trial court erred in granting the defendant's motion to dismiss. Having established that the trial court erred by granting the defendant's motion to dismiss, the next question becomes what to do about that error. Now, in its discretion, this court can proceed to adjudicate the merits of the parties' controversy when a trial court has improperly granted a motion to dismiss. Granted. Here, though, this court should not do so for 4 reasons. First, the defendant hasn't answered yet. And under this court's precedent, including both Blackwell v. Haslam and Cannon County v. Wade, I believe, Judge Clement, you authored both of those opinions, that fact supports remanding rather than plowing ahead. Second, Mrs. Salmon was not afforded a fair opportunity to brief her merits arguments in the trial court. Down below, the defendant filed a motion to dismiss. The only question presented by that motion was whether Mrs. Salmon's complaint should be dismissed for failure to state a claim. As a result, that's what we briefed. What we didn't do, because we never had occasion to do it, was file summary judgment briefing at the motion to dismiss stage. It would have been procedurally inappropriate to do that, and we certainly were not on notice that the trial court planned to disregard this court's precedent and consider the merits issues presented in this case prematurely. Third, this case presents what is at least an as-applied constitutional challenge on which the Attorney General is entitled to be heard. But the defendant has not served notice of that challenge on the Attorney General, so the proper approach is to remand and allow the important constitutional questions presented here to develop in the normal course. Fourth, as the defendant concedes in footnote 1 on page 9 of its brief, the trial court did not even fully adjudicate the merits of the parties' dispute. Here's what they argue, quote, "The Chancery Court made no ruling on the merits of Salmon's argument concerning pre-existing Tennessee public policy. As such, there is nothing for this court to review, and that section of Salmon's brief is not ripe for appeal," unquote. In other words, the defendant itself acknowledges that the trial court didn't even finish the job here. As a result, remand is going to be necessary anyway, because Mrs. Salmon is entitled to have all of her claims adjudicated, and piecemeal appellate review, in which this court adjudicates some merits issues now and others in a second appeal following remand, is heavily disfavored. Thus, for all four of those reasons, or really for any of them, this court should reverse the grant of the motion to dismiss, vacate the trial court's merits order, reinstate Mrs. Salmon's complaint, and then remand for further proceedings. If this court does reach the merits question presented in this case, though, then it should reverse. Both the comprehensive text of Tennessee Code Annotated Section 2934-103 and informative legislative history support the conclusion that the General Assembly did not intend to restrict the statute's application to post-2018 settlement agreements. Trial court's constitutional analysis below was also demonstrably wrong. It failed to identify, much less apply, the correct legal standards, and the defendant does not even defend the trial court's erroneous reasoning on appeal. Further, despite having the burden of establishing that Section 2934-103, which is subject to what is essentially rational basis review, violates the contract clause as applied, the defendant has not even attempted to meet its burden in this appeal. Under the Tennessee Supreme Court's analysis in Ponderi Pende versus FSD Corp., there also is no retroactivity problem here regardless. The defendant's only response to that opinion is to argue that retroactivity for purposes of statutory construction means something different than retroactivity for purposes of contractual construction. But the defendant cites nothing to support this curious theory, which intuitively makes no sense. Beyond that, even if Mrs. Salmon's proposed construction were retrospective, Section 2934-103 is a remedial statute that declares pre-existing public policy and does not impair any vested rights anyway. The reason is that Tennessee law has always contemplated that future legislation would have the result of modifying or abrogating contracts already in effect, and neither the defendant nor anyone else has ever had a vested right under Tennessee law to cover up child sex abuse. For all of these reasons, the trial court's flawed merits ruling should be reversed, and if you reach the merits, you should grant declaratory relief in my client's favor. There are other errors that warrant reversal too. First is the trial court's blanket sealing order of the entire case record, which granted wholesale sealing that was broader than the defendant even requested, based on sealing arguments that the defendant lacked standing to make. That was error, and also transformed this case into a secret proceeding that is literally reminiscent of the Star Chamber. Thus, at minimum, the trial court's blanket sealing order of the entire case record should be reversed with instructions to comply with mandatory sealing standards. Second is this court's own order resealing a document that was published to the court's public docket and made available for 6 days to anyone with an internet connection. It was a document that they filed. This court unsealed it. It was published, and then it later resealed it. In our briefing, we've cited a phalanx of authority that instructs that that was improper. The defendant's only response is to assert incorrectly that all documents start out unsealed, though that clearly is not true. Thus, this court's own sealing order should be reversed and the document at issue unsealed. For all of these reasons, this court should reverse. If you have any questions, I'm happy to answer them.
It's my understanding that the issue has been raised that the petition or complaint doesn't state sufficient facts to establish an actual controversy.
I don't know how that could possibly be true, right? So we've pleaded all the facts necessary to establish that there is a controversy between these parties over whether the settlement, the confidentiality provisions in this contract are void as violative of Tennessee public policy. As Judge Bennett wrote in Carcinovich, that is an actual controversy, the end.
All right, thank you.
What about, this gets to the merits, and I know we may never reach that, but isn't there a presumption that statutes are to be construed prospectively?
Yes, there is a presumption. It's not a controlling or conclusive presumption.
Well, what in the statute lets you think that it could be construed retroactively?
Sure. So two things, both text and legislative history, both of which are important to the inquiry. So let's just read the statute. Tennessee Code Annotated Section 2934-103 says, notwithstanding any law to the contrary, any provision of a settlement agreement that has the purpose or effect of concealing the details relating to a claim of child sexual abuse is void and unenforceable as contrary to the public policy of this state, except that identifying information concerning a victim of child sexual abuse shall be deemed and maintained as confidential. So no indication that this is limited in any way. It's a broad statement of Tennessee public policy.
Well, don't you have to indicate that it's to be retrospective? I mean, don't you have to do more than what's here?
I don't think there's
just because they say any, that doesn't mean going into the past, does it?
If that's all we had, it might matter more. I don't think there is any kind of clear statement rule. Certainly this court hasn't applied one. But that's not all that we have here, right? So there are two statutes enacted on the same day, both of which involve settlement or contract agreements to conceal sexual misconduct, right? Enacted by the legislature on the same day, signed by the governor on the same day. One of those statutes says it's effective starting on the effective date onward, the other one does not. There's also a host of Tennessee statutes, we've cited at least 3 of them in our briefing, which void contract provisions under Tennessee public policy, and all of them state they are effective from this date onward. This statute does not, right? Those things matter. Certainly passing 2 laws on the same day of the same legislative session dealing with similar subject matter, one of which has this forward-looking only provision, the other one which does not, that matters to the inquiry.
Well, I looked at the public chapter this morning, and it had the usual provision of this act shall take effect upon becoming law, the public welfare requiring it. Doesn't that indicate prospective?
Well, it's different than the other one that was enacted the same day, which said it shall apply to agreements executed or renewed on or after that date, right? So that there is meaningful difference in the text of these 2 statutes on similar subject matter enacted the same day.
Okay.
And I know you're out of time, but just to confirm, though, that you have a prospective argument here as well, of
Yes.
course, and it's the corollaries that no longer after the statute can you avail yourselves of the Tennessee courts to prevent that disclosure.
That's exactly right. Under the Tennessee Supreme Court's reasoning in Parn Depende, this is not a retroactive application. Thank you.
All right, thank you. Good morning.
Good morning, Your Honor. Go back and get my water.
Certainly.
Maybe avoid the fire.
It seems to be a necessity today.
Well, it's only because of my cotton mouth, so. May it please the court, Alan Hall of the Williamson County Bar. And I'm happy to address any, it feels like to me that maybe we ought to just start with the questions and just kind of hit them as we go along. The first question is, well, we shouldn't be here at all because this is a motion to dismiss, and courts should never, according to the plaintiff, rule on a declaratory judgment on a motion to dismiss stage. And that's not what the law says. The law says it's rare. And you all have said over and over and over again, as Mr. Horowitz points out in his very eloquent and long brief, that there are plenty of times that courts have done this and they shouldn't have done it. And you all have told them, as he points out, time and time again, and you should forcefully tell this current trial court that she should know better. Well, here, there are no set of facts, that will ever change the outcome of this case. And that makes it ripe for a motion to dismiss. It's a very simple case, and the plaintiff has done a wonderful job of obfuscating the matters and the facts. The facts are very simple. On November 8th, 2016, a settlement agreement, a contract between Fellowship Bible Church and the plaintiff was signed. On May 11th, 2017, an amendment to that contract was made. 1 year and about 5 days later, the Tennessee General Assembly passed a statute that says you can't have settlement provisions in a agreement of this type, concealing child sexual assault. We don't argue that that law is unconstitutional. I've never argued that that law was unconstitutional. That law doesn't apply to this contract for the reasons that Judge Bennett has already pointed out. The statute does not say that it has retrospective application. And the law is clear. The Shell case makes clear, despite what Mr. Horowitz's and the plaintiff's assertions to the contrary, the Shell case makes clear that to have a retrospective application of a statute, you have to say, this applies in the past. They didn't say that here. We strained the gnat to swallow the camel to say that, oh, well, they passed a statute that's like this statute, and they said it only applies in the future, and they didn't say this one only applies in the future, so therefore this one applies retrospectively. It just doesn't make sense. So from that aspect, the motion to dismiss was proper because you can't have this retrospective application to this contract in violation of the state and Tennessee constitutions. It's an ex post facto law. We all learned it in law school. And that gets to the sort of the merits issue here, that this is in fact an ex post facto law. It's not a public policy issue, it's a contract issue. It's a contract issue that this contract was entered into. The parties bargained for these several things that they bargained for in the contract. One of those things that they bargained for in the contract that was legal at the time was, for lack of a better terms, a gag order. And now the plaintiff would have you say, oh, that's okay, don't worry about it. That contract doesn't matter. Tennessee Constitution doesn't matter. Federal Constitution doesn't matter because they didn't say that this statute had retrospective application. It's not anything near a non-disclosure agreement. And there's just nothing left to be discovered. I mean, even if this...
I apologize, I'm a little confused. You say it was in essence a gag order, but it's not anywhere near a non-disclosure agreement?
Well, I'm talking about the statute that he applied it to, the quote-unquote bill passed on the same day regarding future non-disclosure in employment issues with respect to versus non-disclosure in sexual assault. I probably am overstating it a bit.
That's
there,
fine.
Your Honor. Just
It may be my fault.
What about the notice to the Attorney General?
We've never said that this statute is unconstitutional. The statute that the legislature passed that took effect on May 15th, 2018 is a constitutional statute.
If it's applied prospectively.
If it's applied prospectively.
But the question is whether it is or not. So doesn't that involve the constitutionality, and shouldn't the AG have been involved?
I can see that argument. I would disagree, though, because it's not the, they were asking for future application of that statute, that it would be, we're saying that you can't apply it in the manner that they're requesting because the statute doesn't have retroactive application. In other words, the statute can't have retroactive application.
Because it would be unconstitutional.
Fair.
Okay.
Yes, violate the contracts clause.
Okay.
But then again, that goes to the merits argument. With respect to the sealing issues, unless there are other questions on those, I want to make sure I address all the merits questions. The sealing at the trial court level, it's important to understand the record and what's happening here is they're appealing, or the declaratory judgment action is about this minor settlement agreement from a case in 2017 that was sealed. And they didn't appeal the sealing of that record. But the complaint and all of the materials are in the complaint of this current case that is on appeal attach the complaint from the prior case. And even the plaintiff filed his case under seal. And so, because the prior case was under seal, the court determined, for all the reasons in that prior case, that this case should remain under seal. And she made the correct decision, not only based on the factors enumerated in the plaintiff's briefing, but because of the prior history of the prior case. And that case was sealed. And the plaintiff makes a big argument about the standing, and I didn't have standing to raise the issue. I just merely pointed out to the court that all of the parties in this case were not before the court. I wasn't trying to assert standing on behalf of the minor child. My point was, at the motion to dismiss argument, was that there are people with a vested interest in this case remaining sealed who are not here. And therefore, the case should remain sealed because it was already sealed under the prior case. And then I just want to, and I'm unclear, I'm like the lawyer before me, I'm a little unclear on how to argue this court's rules and what happened, but I'd just like to factually go through this whole public document issue just to make it clear, and I was unclear on how to cite to the motion record, so if you'll just indulge me for a little bit just to kind of go through the history of the filings at this court. So the plaintiff filed a notice of appeal on March 12th. And I filed, improvidently, what I call a prophylactic motion to seal. And I did that based on Rule 15 of the Court of Appeals rules. And I did it particularly based on DI. And my experience here is limited to, this is now my 5th time in front of the Court of Appeals. One time, 2 times I was only in briefing, and the other 2 times were in Zoom, so it's actually my first time actually here in person, and let me tell you, it's a whole different ballgame when I'm not standing in the comfortable confines of my kitchen. So I filed this prophylactic motion to seal based on this statement in DI of Rule 15 that said brief applications, motions filed originally in this court will not be filed under seal absent a showing of extraordinary circumstances. And all this information was in the record, and I was worried about it. And so I filed this prophylactic motion to seal on 3/27 into the true filing system. The plaintiff filed a response. The court issued an order, which I didn't understand, didn't come to me electronically like all the other orders in cases that I have typically come to me or electronically, and it doesn't even come in the true filing system. It comes via snail mail, or it's posted online at the Tennessee Courts Office of Administrative Courts website. It's not, and to be clear, I followed the procedure.
Wait a minute, are you saying that this court put down an order and you didn't receive that order?
No, sir. I received the order. I just received it via snail mail in my mailbox 2 days later.
Okay.
Because I didn't know to check the Administrative Office of Courts website. I thought I'd get a notice, and I was checking the True File website, refreshing it to see, and it's not posted there. And so
You might want to inquire with the clerk to make sure that they have your email address. They should, but I can't explain the mechanics of that.
Well, and so I understand the mechanics now, because as soon as I got that order denying my motion to seal, I understood, at least per the procedure, that my materials would be coming back to me. And that's what my motion to reseal on the 5th says, is I improvidently filed these things because I thought if you denied the motion to seal, that information would be coming back. I didn't understand that this would automatically become a public record. As soon as I got the notice, I called the clerk, I filed the motion to seal and that's how we got the per curiam order that brings us here today. And that's how we have Mr. Horowitz saying that you can't take back a public document. And I suggest to you, under the rules of appellate procedure, that you can. And Rule 1 and Rule 2 of the Tennessee Rules of Appellate Procedure, and if certainly there is a case for the application of Rule 2, it is right here. The primary purpose of this rule is to make clear the power of the appellate courts to suspend the requirements or provisions of any of these rules in a particular case. And that's the issue here. And I appreciate your attention and time. Thank you.
Thank you, Mr. Hall. Mr. Horowitz, your rebuttal.
Your Honors, this court has held repeatedly in at least 5 decisions authored by just 2 members of this panel, and many more beyond that trial courts are not supposed to grant motions to dismiss under the circumstances presented here. There was Remus versus Nunn. Judge Bennett, you authored that. There was Parsley versus Manchester. Judge Clement, you authored that, and Judge McBrayer, you were on the panel. There was Carcinovich versus Kempe. Judge Bennett, you authored that opinion. Judge McBrayer, you were on the panel. There was Blackwell versus Haslam. Judge Clement, you authored that opinion. Judge Bennett, you were on that panel. There was Cannon County Board of Education versus Wade, published decision. Judge Clement, you authored that, I believe. Then Judge Koch was on the panel with you. It is frustrating, to say the least to me, but I imagine also to you, that trial courts continue to violate this crystal clear doctrine that says if there is an actual controversy alleged, do not grant a motion to dismiss for whatever reason. Trial court below was unable to comply with that precedent. This court should reverse and remand with instructions to reinstate the complaint and have this proceeding go forward in the manner in which it was intended. I heard opposing counsel say that this agreement was lawful at the time of contracting. We dispute this, obviously. We do not think that that is true. We think that pre-existing Tennessee public policy prohibited concealing sexual assault of children at the time of contracting as well. We've noted that in our briefing. They didn't respond to it, but they do acknowledge that the trial court never adjudicated it. So this has to get remanded anyway. Sealing. They argued, and the trial court ruled on their claim that sealing of this entire case record, including a Tennessean article and a copy of the law in question, should happen here because it would harm the plaintiff or her family. They are not the plaintiff or her family. They have absolutely no standing to make arguments about harm to the plaintiff or her family. That is the only basis for sealing that the trial court gave here. That order is clearly wrong. As for this court's resealing order, major First Amendment doctrine prohibits resealing of documents that a court has already unsealed and published to the public. Respectfully, counsel's misunderstanding of the rules and noncompliance with them is not a justification for violating that major First Amendment doctrine. Lastly, I just want to hit this non-retroactivity point. We are not asking for retrospective application. If Mrs. Salmon had violated this agreement in 2017, legislature passes the statute in 2018, and then she gets sued for breach and says, I am retroactively immunized from liability based on this statute. That would be a retrospective application under the Tennessee Supreme Court's precedent. That is not what we are asking here. We're asking for forward-looking prospective relief only, that going forward, Mrs. Salmon cannot be found liable for breaching this void as violative of Tennessee public policy provision of her settlement agreement. This court should reverse.
All right. Thank you, Mr. Horowitz and Mr. Hall, for your arguments. We'll take this matter under advisement.